Hello and welcome to Law 2024 Online Commercial Property Autumn Shape the Debate with me, Mark Shelton, and Richard Snape.
Hello.
So today's Q&A is due to last 1 hour, and that's going to cover your pre-submitted questions. The recording of today's session will be sent out by email within the next few days, so do keep an eye out for that. The event's sponsored by Watchman, and Watchman is a specialist insurance policy which is only available to solicitors, and it provides insurance for unoccupied properties. It's been revolutionary in changing the way that probate solicitors protect their clients' estates by reducing initial pressure on your funds while you're still trying to access the estate and sell the property. Watchman achieves this as solicitors don't have to pay a full upfront premium. Cover is secured by simply paying a small deposit and continues with a daily premium charge that's deferred until the property is sold or transferred for up to a year. No finance agreement and no cancellation charges. It's also available for homes where clients are in care or with reduced legal capacity. Getting you started and arranging cover is easy. If you'd like to learn more about Watchman, you can contact their helpful team on 01935 389 812. That's 01935 389 812, or via their email watchman@practiceenterprise.com. So some introductions. I'm Mark Shelton, and I've worked in major commercial law firms for 29 years. As a property litigator, I've acted for a range of clients from FTSE 100 investment companies and major corporate occupiers through to small businesses and individuals. I'm an expert in commercial property management law, and as well as advising on the structuring and documentation of transactions, I've conducted a wide range of commercial property disputes, acting both for landlords and for tenants. I'm now a non-practicing solicitor and work as a commercial property management law trainer, putting that expertise and experience, I hope, to good use in training both lawyers and surveyors. As part of Law 2024 Online Commercial Property, my sessions have included interpretation and drafting of repair obligations in leases and repurposing issues for neighbours, landlords and tenants. And Richard, our other speaker, has been the head of professional support at Davitt Jones Bold since 2022. I beg your pardon, 2002.
I wish it was 2022.
He speaks at numerous courses for law societies all over the country, various public courses, in-house seminars within solicitors' firms, and has also talked extensively to local authorities and central government bodies. Always a pleasure to present with him. And his areas of specialism include both commercial and residential property. In particular, in relation to local government law, conveyancing issues, development land, commercial property, and encumbrances in relation to land. As part of Law 2024 Online, Richard Snape's sessions include the Landlord and Tenant Act 1954, when it applies, and commercial leases update. So, with all that out of the way, let's have a look at some of the pre-submitted questions that we've been receiving from you. The first one, I think, is for you, Richard. This is, can someone working from home be a business tenant?
Yeah, it's a topical one at the moment with post-lockdown world. The standard case on it is a case I think I mentioned called Shell Investments in Saldana. That's the way you pronounce it, back in the 1976, I think, which basically said if you are living in premises where you're running a business, then unless you're breaching the user covenants in the lease, or if you're just bringing work home with you, it's ancillary, you come within the business tenancy regime, which is easily the case if you don't realize what you're doing, or the landlord doesn't realize what's happening, because I'm not going to serve walking notices and you'll come within the 54 Landlord and Tenant Act. There's actually been a more recent case that I mentioned in the update. This Kensington and Chelsea and Melcraft. You've come across that one earlier this year.
Yeah. That was yes, that was an interesting one. So I'll be interested to hear what you have to say about it. Yeah.
I'm not sure it was correct in the second part of it, because it's sort of two parts. Are you a business tenant? Melcraft was a property management company, but the sole director, seems to have been the sole director, was actually sort of living in this premises on the Portobello Road in London. And the court decided it was a business tenancy in those circumstances. They went on to say that the landlord then wanted an argument that the council wanted this argument that we want to occupy for our own purposes under ground G, even if you are a business tenant, because we're going to put homeless people under our statutory obligations, temporary accommodation for the homeless in the premises. And the court said that you're not intending to occupy the premises, the homeless people are, so they failed on that, which I've got my doubts about. But the thing you can do since October of 2015, you can create under the Small Business Enterprise and Employment Act that year, you can create home business tenancies. If it depends on the terms of the leases, but if you're sort of allowing or consenting to a business that can be reasonably run from home, and that won't come within the 54 Act. The exception, unfortunately, is trading in alcohol. You can't convert your tenanted property into a pub. But I don't know if you've got any.
Yeah, with that home business tenancies thing, that's interesting because it has to be a business of a nature which can reasonably be carried on at home, doesn't it? We have no case law on that, but I guess it's obvious enough. I mean, what you and I do, Richard, I would suggest could reasonably be carried on at home. But if I was importing and distributing flat screen TVs with lorry movements and things stored in the garage, I think that would be a different matter. But the Melcraft case is, I think it's kind of interesting. The local authority landlord got themselves into a bit of a pickle, didn't they? Because, I mean, first of all, they seem to have messed up the contracting out because it was supposed to be a contracted out lease and they got that wrong. Also, why did they grant the lease to the company? Why didn't they grant it to the director who was living there? Then there wouldn't have been a problem because I don't think there would have been any sensible argument. It would have been his business that was being carried on there.
Yeah.
They could have prevented security of tenure by having a prohibition of any business use in the tenancy. That would have been nice and easy. So they seem to have got all sorts of things spectacularly wrong. So but there it goes.
Right. I mean, the other problem you've got, even if it is something like a home business tenancy, if you're sort of receiving clients in your rented property, then it's got a lot of implications outside things like the 54 Act, like you pay business rates or council tax on the premises.
Yeah.
And also, do you need a change of use for planning purposes? Are you breaching restrictive covenants and the like?
Sure. I mean, it's but I mean, the world of everybody doing at least some work at home is, or most of us doing at least some work at home is here to stay. I think so.
I think we're going to have a lot of issues with it in the future.
Yeah. Okay. Next question, one for me. You said, I said that unless a time limit is stated in the lease, a landlord can require reinstatement of alterations right up to lease expiry, even if it's too late for the tenant to do the work. Surely the landlord would have failed to mitigate its loss, so the tenant wouldn't be liable for any damages. I think the answer to that is that there's no obligation to mitigate your loss unless there's actually a breach of covenant. And there can't be a breach of covenant until you've served a reinstatement notice and the tenant has failed to reinstate. So it shouldn't affect the timing of the notice. That shouldn't be an issue of mitigation. And I don't think that's been argued in any of the surprisingly few cases on this topic. And I think the consensus view is that you can serve a valid notice and say right up to lease expiry. The landlord can swan through on the day before expiry and say, "Oh, would you mind taking the mezzanine floor out before you leave?" And that's it. Which I think is sort of it feels monstrously unfair from a tenant's point of view, and particularly if you've got a tenant who's trying to exercise a break option, which is conditional upon compliance with covenants, and they can't comply with that covenant in time. I'm not aware of any break option case which has ever turned on that, either reported or in practice anecdotally. But it's a potential problem, and I think it's odd that tenants don't more often kind of bargain to have a time limit in the lease, saying you've got to notify us within 2 months or 3 months before lease expiry, so they can do something about it. I know the Model Commercial Lease Code, the Model Commercial Lease suite of documents has a nice structure whereby the tenant notifies the landlord 6 months before lease expiry, sends them a list of all the alterations they've done and says, please notify us which ones you'd like us to reinstate. The landlord's got 3 months to notify them. and then they've got 3 months to do all the work the
Mhm.
landlord has notified them of, and no obligation to do anything else. And that seems to be a very sensible way of dealing with it. And is there anything to add, Richard?
Not particularly. I just started to think about anticipatory breach, but that took me to my long time ago and degree level contract wall. But so I don't go down there. I think there's a case called White and John Warwick, don't have to if it's anticipatory, but don't ask me the detail.
Yeah, I'd have to go and brush up on that one, I think.
Long time ago. But yeah,
Okay. Okay, and another one for you. Do you think that the McDonald's case is correct? That's putting you on the spot.
I presume that's the McDonald's in Shiriyama, Shokistan.
I assume so. Yeah.
And from May, there's quite a few McDonald's cases over the years. Uh, I the long and the short of it, I'd be interested in seeing what you think about it, Mark. But because it was about one of the rarely litigated areas, or the Section 37A of the 54 Act, which was a predecessor in Section 55, and Section 37A came in 2004 with all the changes, and it was a flagship McDonald's in County Hall, next to London Eye. And it, where the landlords, Suriyama Shokusan, obtained possession, claiming 31G. They wanted to occupy for their own purposes and run a particular Japanese restaurant, Zen Bento, and changed their mind at a later stage. I mean, there was a lot of sort of evidence and emails and the likes as to whether they've had an intention to do this at the very first. But eventually, they had various problems during the lockdowns. They could only run as a takeaway initially, and then they closed down and started again. It's a different type of Japanese restaurant and bakery, a Japanese bakery and coffee shop. And McDonald's sued under Section 37A basically for misrepresentation. The court didn't award a new lease on the basis of the representations or misrepresentations of the landlord. My own feeling is that, well, it's always going to be difficult evidentially to prove the landlord didn't change their mind, but the court accepted that that was the case in that particular situation. And then I would be interested in hearing what you think, but Section 31G doesn't actually say that you have to occupy for a very specific purpose. It's just for the landlord's purpose of their business or residence, and yet let alone a sort of Japanese restaurant. So I personally think it's a bit dubious.
It's yeah, I'd say it's perhaps a bit borderline. I mean, I think uh, on the face of it, you say, well, what difference does it make one sort of Japanese restaurant over another sort of Japanese restaurant? I think the question is that you've got to have sort of firm and settled intention to occupy, haven't you? It's got to be something which is not likely to change. And I guess if you're juggling different ideas, well, we're probably going to do this, but we might do that. I suppose that throws a doubt on whether the intention is sufficiently firm and settled. So, but I agree, it seems like a peculiar sort of outcome. But I think I can see that it's just about arguable. I mean, it calls to mind there was that case Inclusive Technology in Williamson about 10 or 12 years ago, also on 37A, where the landlord was opposing on ground F. And this is probably a much more kind of common situation which is going to arise, where the landlord's got a redevelopment scheme on foot, and as is usual, the landlord's idea is, well, we'd rather do scheme A if we get the planning consent we want, and if we buy in this extra bit of land, and that's our preferred scheme. But if we can't get the planning consent, we'll do scheme B. If we can't buy in this bit of land, we'll do scheme C. Landlords are very often kind of juggling all those things, and it may depend on the progress of the planning system and all the rest of it. But in the Inclusive Technology case, as I recall, the landlord decided to put its scheme off for a couple of years, but didn't get around to telling the tenant. So the tenant found other premises and relocated. And when they found out what had happened, they sued for compensation. I think probably quite justifiably got it in that case. But it is a difficult one because you want to, on the one hand, you want to give full disclosure to the tenant and say, so you're not exposed to claims for compensation. So this is what's in our mind. This is what's in our mind. This is the state of our intention. On the other hand, the more you say, well, we're juggling all these other possibilities, the more you weaken the idea of the kind of firm and settled intention. So it's quite a difficult one, And I
Yeah.
think the judge in that case said the sort of thing which is very easy for judges to say. He said, it's not necessary to keep the tenant informed of every twist and turn of the landlord's thinking. But I think that's quite a difficult judgment often in
Mhm.
practice.
Yeah, it's one of my favorite, well, perhaps even my favorite quote in the whole of commercial leases. Cunliffe and Goodman, the intention's got to be out of the zone of contemplation and into the valley of decision. And it's a shame
Yes.
that people don't talk like that anymore. But I say it just seems strange to me that it seems to sort of, again, it's a sort of question of fact as to, looking at the emails and what was really intended, but that you can't change your mind at a later stage, and decide to go on, what's the difference? I'm not an expert in Japanese restaurants, but what's the difference between the Zen bento and the restaurant that finally turned up? I'm not sure about that.
Yeah. I mean, in some ways, it's similar to that issue with dilapidations claims and the landlord's intention to refurbish the property and carry out
Mhm.
work to the property at the end of the scheme, whether that at the end of the lease, and whether that reduces or erases completely any tenant's liability for damages. And there was that case, was it PGF2 and Sun Alliance, a,
Yeah, the
a few years back?
one in Soho,
Yeah, and the tenant vacated, and the landlord did this massive refurbishment, and then claimed for dilapidations against the tenant, who, quite understandably said, "Well, you're joking. You've done this massive scheme of refurbishment that's superseded any dilapidations work we would have done." And the landlord said, "Well, you know what? At lease expiry, we really hadn't decided whether we were going to do that refurbishment or not." And they were able to persuade the judge that was the case. And so, yeah, this whole business of landlord's intention at a particular point, it's always a bit of a minefield in terms of proving it and investigating
yeah.
it. Yeah.
But we'll have to see. It doesn't seem to be going to appeal from what I could see.
No, no. Okay, moving on. And one for me. If a landlord serves a Jarvis and Harris notice, and when it starts doing the repair work, further disrepair is found, does it get around any problems if the notice requires the tenant to put right any further disrepair found while dealing with the specific items listed? Okay, so just a quick recap of the Jarvis and Harris procedure is, you compile your schedule of dilapidations, you serve a notice on the tenant saying, please do all this work set out in the schedule. Tenant doesn't do it, and you've got to write in the lease to go in and do it yourself and send the tenant the bill, which may or may not be an effective way of dealing with dilapidations in mid-term, but gets you round the hoops of the Leasehold Property Repairs Act 1938 at any rate. Yeah, I say it may or may not be an effective remedy. One of the problems with it is precisely this about what happens when you find any further work that needs doing, as you always do. When you break open surfaces and get into the roof void and all the rest of it, you always find stuff that needs doing. And you can either, it's a solution with that. It's a problem without a solution, really. You can either pull your contractors off site and serve a new notice and wait another 3 months, which is probably not the most sensible idea. You can just cover it up and forget about it and leave that disrepair in place, which also probably isn't a very good idea. In theory, because that work isn't identified in your schedule, it's a trespass for the landlord to go ahead and do that work, and the tenant could actually injunct to prevent the landlord doing it if they were so minded. But in any event, if the landlord does do it, I think they just have to accept they don't get to recover the cost of that additional work from the tenant because it's not included in the schedule with the notice. So that's the problem, and that this solution suggested by this question is one I've actually had suggested to me before, which is that you have some sort of general wording in the notice, so you refer to all the work set out in the schedule and include a reference to any further repair work which is identified in the course of doing the work. And I see the thinking, and it's ingenious. Personally, I don't think it works. I think in terms of what you're requiring the tenant to do, all you're requiring them to do with your notice is comply with their covenants in the lease. So if in the course of doing the work they find some more disrepair, well, then if that's included within the covenants in the lease, it's their responsibility to do it, and having included some general wording in the notice doesn't affect that. They've still got the obligation to do it. But really, what Jarvis and Harris is all about is what happens when the tenant doesn't do the work. And that's the whole point. And, if the landlord is going to make a claim on the basis of, well, on the one hand, here's the bill for the work which was included in the schedule, which you didn't do and we have done. Fair enough, that's what it's all about. If you include the further element that says, well, here's the bill for the work that wasn't included in the notice and which you haven't done, but which we did in the course of carrying out this other work, I don't think it works. I think it's a bit of a reach, that one. Um, it may be. I don't know whether people do that as a means of trying to give themselves at least an argument on it. I guess the reality is that most of these things get negotiated out anyway, and it's quite unusual for a landlord to actually get to the stage of going into the property and doing the work. Yeah, I I don't think that's a way around the problem. I think is my answer. Don't know if you have any views on that,
Yeah,
Richard.
I mean, I think where it's a way of protecting your reversion is when the tenants have upped and left and done a runner with never be seen again. And those kind of circumstances, you're not expecting to get the money back, but you just want to protect your reversion. Well, the other thing about Jarvis, and Jarvis, I get used to Jarvis, it's not spelled like that. But the other thing about Jarvis and Harris is it probably triggers the Defective Premises Act, Section 4. And because you reserve the right to enter and carry out works, then you're liable. It makes the landlord liable for anybody who might reasonably be affected by disrepair.
Yes, yes, that's true.
Most of the Defective Premises Act only it says it applies to dwellings, but that applies to property.
Yeah,
Presumably, that means there's a difference, and they almost certainly are. What people should make sure they're insured against it.
sure. No, I think that's right. But I mean, I think one of the it's a funny thing, Jarvis and Harris. And one of the reasons that people use it is that the whole basis of Jarvis and Harris is your claim to recover the cost of the work is not a claim for damages, it's a claim for debt.
Yeah,
Therefore, if at the end of the lease you raised a dilapidations claim, and you anticipate that Section 18 of the 1927 Act would severely limit the amount of damages you'd recover, well, you get round that if you do the repair work before lease expiry and recover the cost through Jarvis and Harris. So that's one angle to it. But say it's something to use where a tenant's done a runner and you don't expect to get paid. I can think of a couple of instances where it's been really useful in actually getting work done. One is just anecdotal, and I was talking about dilapidations at a course, and the surveyor said to me, I was saying, we served a Jarvis and Harris notice in relation to an industrial property, a large factory in Leeds, and we were asking them to put a new roof on the place. It cost £1 million. We were really just trying to negotiate the break clause out of the lease. He said, "Bugger me, they did it. They put a new roof on it. It cost £1 million." And 3 years later, we put a bulldozer through it. So so people do respond positively to these things, and perhaps a bit more typical one that I actually had experience of is acting for a institutional landlord, and we had a tenant who was a major corporate occupier, FTSE 100 company, and all the rest of it. A Jarvis and Harris notice was served on them, and that's a reason any litigator knows. Every now and again, a dispute will turn very acrimonious for no apparent reason, and this one got very acrimonious and ill-tempered. We maintained our position that we were going to go in and do the work, and we'd get an injunction to make them let us go in to do the work if necessary. We maintained that very firmly up to about 2 weeks before the notice expired, at which point they negotiated a program of work. They didn't do everything on the schedule, but they spent about 300 grand on it. At the end of the day, we kind of looked at the file, and we had that much correspondence, and it was all it looked like a big fight. But at the end of the day, we'd served a notice, we'd had some correspondence, and they spent a six-figure sum on the property. So there's a use to these things. Anyway, that's possibly a bit too much anecdote. We'll go on to another question. One for you: Are high street rental auctions in force yet?
They were meant to be, but everything's been thrown around by the general election being called as early as it was. It's this idea which I've got my doubts about its effectiveness. It's only in England as well. It's Part 10 of the Levelling Up and Regeneration Act. which received the royal assent in October the 26th, I think it was last year. The idea of local authorities being able to, basically against landlords' wishes or owners' wishes, put empty premises up for auction is the basic idea behind it. Back in March, the regulations were passed to pass further regulations, which is the way things are done. In May, the government announced they got 10 pilot areas up and down the country. One, including Stoke-on-Trent, my hometown, where I was born, but where I live now. Cheshire was sadly missed out, the Edge was. But anyway, they had 10 pilots, mainly in the north, but North Midlands, but Clacton, Tendring and Essex as well, which were going to start the auctions. The anticipation would be the sort of trailblazers, as they were called, would be serving notices in September of this year, and the first auctions would be in October. And for the pilot, all the pilot authorities were given money to run the pilots. It seems to have been thrown in, well, not in doubt by the general election, but nothing seems to be said about it. I did a big course on Zoom for local authorities a week or two back, and no one seemed to know anything about them. In early September, a housing minister, a junior minister, announced that Labour will definitely go ahead with it. But I haven't seen anything recently. I don't know if you have in relation to it.
That's more than I know. I hadn't heard about that announcement or that comment statement by Junior Minister. But I know Labour have given an indication of what they're going to do in relation to various bits of the Act, but I'd not seen anything in relation to Part 10. That said, it was a part of so when it was a bill going through Parliament, that part of it had cross-party support. Mm-hmm. It would not surprise me at all to see it implemented. Yeah, we'll see.
It's somebody I've never heard of, but it was on September the 5th, I think it was. And I've not heard anything since. So I suspect it will go ahead, but I say whether it's this year or not is another matter. Sure. Whether it's effective or not is another matter as well.
Sure. Well, I think that's a follow-up question which we got in a minute, actually. So we'll maybe have another chat about the ins and outs of it. But in the meantime, another one for me. Tenants are widely limiting repair liability by schedules of condition or financial caps or excluding some parts of the property from the repairing obligation. It's a short step to having no repair liability at all. Can you comment? I can. I would very often suggest to people, well, why bother having a repair obligation? Because when you look at what actually happens in practice, you walk down your high street and all the shops look gleaming and gorgeous and little retail palaces, and then you sort of look up and you can see all the kind of flaky paintwork and the rotten window frames and buddleia growing out the roof and all the rest of it. And you sometimes wonder, do people actually ever spend money on repairing a property? You get to the end of the lease, there will be a dilapidations claim. The landlord expects they're going to get a check of some size, and there's a big bun fight. Lawyers and surveyors make money, and at the end of the day, some sort of check changes hands. The landlord doesn't think it's enough. The tenant thinks it's outrageous. Does the landlord spend it on repairing the property? Maybe some of it. There's no obligation to do so. And it all seems to me that it's a pretty inefficient way of maintaining property or providing for the maintenance of property. And if you have a kind of inclusive rent sort of arrangement where the rent is higher than it would otherwise be to reflect the fact that the landlord retains the repairing responsibility, and subject to maintaining it in a sort of tenantable condition so the tenant can occupy the property effectively, the landlord can do as much or as little as it wants on repairing the property. It seems to me to be a perfectly sensible way of dealing with things. Not for every property, but for a lot of the kind of short-term, low-value lettings that we see these days. And I think, if you look at some of the standard form leases which are out there, and I think, anecdotally talking to people, surveyors are increasingly documenting leases themselves without reference to solicitors using standard form leases because they don't want to pay those lawyers lots of money, and you can understand it. And for example, the what is it, the BPF, short-term commercial lease, that is an inclusive lease. There's no repair obligation on the landlord there. Similar kind of situation with the RICS, small business retail lease. So it may be that sort of idea is being adopted a bit more widely out there. But I think I agree. It's a good way of avoiding all this bun fight at the end of the lease, and just having a kind of sensible arrangement for repairing properties. I don't know if you have any thoughts on that.
Not
Yeah,
particularly.
yeah,
I do think of not so much with the short-term leases, but there's a lot of tenants out there who basically shouldn't be agreeing full repairing obligations, but they do.
mm,
And I've always thought the problem with repairs and dilapidations, and not just in the high street, people should know better, is that tenants don't care about what might happen at the beginning of the lease. They do care 10 years later when they get hammered for dilapidations. But in the beginning, they'll just go on with it.
no, that's quite right. And your small business, they don't want to pay professionals, so
They don't even want to pay for a schedule of dilapidations.
no, or a schedule of condition. And I think schedules of
Sorry,
condition,
schedule of condition, sorry. Yeah.
yeah, well, schedules of condition are a dubious worth usually, but and very often, the preparation of the schedule of condition is left to the tenant. The landlord will say, "Oh, go on, you prepare a schedule of condition." They walk around with a mobile phone, click, 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 and take a load of photos. And
I once came
yeah,
across, well, I won't mention where or who,
yeah,
but they were obviously told that, go and take some photos of fungus and mold.
yeah,
And there was mushrooms, field mushrooms that you eat. And they'd
yeah.
obviously got the Sainsbury's or somewhere and got a punnet of mushrooms and put those around the place.
Oh,
I think
that's
that was seen through there. I think they
yeah,
get away with that one.
that's really good. Okay, back to high street rental auctions for the next question. Do you think that high street rental auctions will be a success?
No,
No.
next one. Well, it's local authorities can sort of designate high street or town centre areas with a built environment as being subject to high street rental auctions, and local authorities will obviously what the final version is. Obviously, are the ones who will be paying for the auctions. As was mentioned at the beginning, I do over the years. I've done a lot of work for local government, both surveyors and lawyers, and I don't know many who've got the resources, quite
Mm,
honestly. And it also, to some extent, there are reasons that it happens, but it presupposes landlords deliberately keep properties empty. They might, for sort of, they don't want to set comparables in terms of rental and the likes. But the reasons they tend to keep properties empty are they want to develop the whole row, and they can use that as a defense to potential high street rental auction,
mm.
which like ground F. You don't want to sort of lease out a premises if you're intending to, everything else is empty on either side because you want to develop. And there's not many landlords who think to themselves, let's forego rental and 3 months later have full business rates liability on the premises as well. So I've got my doubts.
It's not what you invest in property for, is it, to keep it vacant and have just outgoings on it and nothing coming in? I mean, it's. I think there's a kind of widespread view outside of government, at any rate, that this is aimed at the wrong target. And why properties are vacant is to do with business rates and online retailing and anti-car
Car
initiatives of one
parking
sort or
costs,
another.
things like that.
So but I mean, it is a bit of an open question whether it'll be taken up. I mean, I think the idea is the local authority bears the costs of preparing the auction pack and doing the marketing, and the successful bidder bears the conveyancing costs.
The landlord has to bear all the bringing it up to standards, having
That's right. Yeah,
releasing them lease and have
yeah,
fire safety assessments and implement them, and asbestos assessments and implement them, and
yeah.
electrical wiring and so on.
Well,
So
I was going to say that's actually precisely why I suspect that there is a chance of it becoming a bit of a established feature of the landscape. I think some more activist kind of local authorities might see this as a way to get the standard of the commercial property stock in their area brought up at landlords' expense, and use the scheme for that purpose. But it's speculation whether local authorities will be interested or not.
I mean, when I've talked to
Yeah,
local authorities about it, they just
yeah,
who's going to pay for all this? I mean, they trailblazing the pilot with the 10 authorities, whatever's happened to that. They were being given by government, I think, £500,000 each.
yeah.
If you give somebody £500,000, they'll do the high street rental auctions.
Hmm.
They have to pay for yeah, pay for the auction themselves. Then they
Yeah.
do setting up of the auction. I'm not sure they will. The other
Hmm.
thing which concerns me is that if there's a need for a consent of a superior landlord or mortgage company
Hmm.
deemed to give consent.
Yeah, and you do wonder um, what the position is of lenders who are lending on properties which may become subject to a high street rental auction, and if the outcome of the process may well result in a lease which is not going to be institutionally acceptable, and a tenant of a covenant strength who wouldn't be acceptable. Um, what's the position of the lender there when their security's at risk? And are they going to be seeking additional covenants from landlords?
Yeah,
Yeah,
I
yeah,
don't think the lenders are going to be at all happy with that idea.
no,
And there are other things besides, but like I mean, you don't need planning permission for a change of use.
mm,
And most of the uses are going to be in Class E, commercial business service use, the thing that came in 2020.
mm,
But one or two aren't. And if you're not careful, it's going to be a way of losing pubs in the high street
mm.
because they need full planning permission. And suddenly you wouldn't need planning permission to change the pub into something else for the duration of the lease, at least.
Yeah, yeah.
So I don't think it's been particularly well thought out, but it's not unique in modern legislation to that effect.
How true. Mm. How true.
Don't
Well,
get me
well,
into the Building Safety Act. But
yeah. Yes. Well, we shall see. Okay, next question. Should landlords be able to automatically require tenants to reinstate their fit out at lease expiry? It's hardly sustainable. Well, I think I agree with that comment. I mean, it's something you see all too often is the so-called fit out and strip out cycle that, the tenant leaves, landlord rips out all their fit out, the incoming tenant comes in and puts in something pretty much the same, and I think what's the point of that? It's not exactly very efficient or very sustainable. I think landlords and tenants are beginning to fret about that a little bit, and uh, yeah, I'm no expert on green lease terms, but I don't know whether this is something which would feature in kind of green lease terms, but uh, I think it would be possible, probably, I would have thought, depending on the type of property, I guess, what sector you're in, it'd be possible to identify certain elements of a fit out where you have a presumption that it wouldn't be reinstated, and uh, you might make the reinstatement requirements subject to a landlord's obligation to have regard to the impact upon the environment and the sustainability of the materials used and so forth. So I think there's people are beginning to think about it, and I think there's probably going to be more pressure in relation to that, whether from the RICS, the professional bodies, or from just from business users. It's probably something where there is going to be some action seen. But I agree, it is rather wasteful the way that things are done very much at the moment. Yeah.
yeah, I think at the higher end
Yeah.
of the market, people have to be seen to be doing these things as part of
Mm.
the ESG requirements and the like.
Yeah.
Uh, Creeping into the not just the higher end, there's a lot of kind of need to show corporate responsibility. And I wouldn't be amazed if one day it's dealt with by statute, quite frankly, but that's probably a long way down the line.
Yeah. Yeah.
You and I might not need to bother about it. But yeah, you should have clauses in the lease that the landlord will not require reinstatement if the alterations add to the energy efficiency of the building and the likes. I
Yeah.
think that's something which is more than legitimate.
Sure. No, I agree with that. Okay. Next question is one for you. Why was it significant in the Annington case that the Ministry of Defence were not in occupation? I
Oh,
confess,
150,
I'm not familiar with the Annington case, so you can educate me
152
on
pages. Don't make yourself familiar.
that.
Uh,
Yeah.
it's a High Court case from earlier last year. It's actually featuring again. It's been in the national news actually. It's sort of Annington Properties Crown. It's a judicial review. Annington Properties. Sorry, the judicial review's coming. Sorry, but it's Annington Properties and the Secretary of State for Defence. And it was about the back in 1996, the Ministry of Defence transferring their housing stock for £1.662 billion to Annington. 55,000 houses. And I think they've still got 38,000 houses, but it transpired it was sold at a massive undervalue. I've seen estimates of over £8 billion, the value now. So the MOD have been trying to get the properties back.
Mm.
And what they basically, it was a MOD kept for freehold. They granted 999-year leases to Annington and then got a lease back for 200 years and then sort of put military personnel and the likes in occupation of these premises. And that was the background. It was meant to go to the Court of Appeal in July, but they seem to have gone back to trying to negotiate. But Annington have brought judicial review for the new enfranchisement legislation. That's for another day. They basically, you come within the 54 Act if you occupy under a lease, at least partly for business purposes, with a few exceptions and likes the ability to exclude. You've got a right to enfranchise under the houses under the Leasehold Reform Act of 1967. But if you come within the 54 Act, Landlord and Tenant Act, you might still be able to enfranchise, but you have to show a residence requirement. And companies and people like the MOD, can't be resident if it's not within the 54 Act. You don't have to show a residence requirement. And so it suited the MOD to argue that we weren't resident in the premises because if we weren't in occupation, sorry, because in that way you're not within the 54 Act, you can enfranchise. And that's one of the things the court decided. They seem to decide 101 other things as well. But you've got the ability, if you don't come within the 54 Act, even if you're not a resident, to actually, if you're not a resident to, you don't, I'll get this right, don't come within the 54 Landlord and Tenant Act, then you can enfranchise the properties. We'll see what happens in the future. When you're talking about £8 billion, they tend to go to appeal.
Well, quite, yeah. That's it's amazing, isn't it? How you can work with the 1954 Act for decades and you still find little backwaters of it that you didn't know, but you didn't know about
Well,
before.
exactly. It's sort of
Uh,
based on. There was a
uh,
case called Smith and Tight in it, which amongst their, they seem to quote everything else under the sun in the case, but they didn't state that one where they said a similar kind of thing.
mm,
The company is not resident; the individual occupiers are the ones who are resident, and therefore you can franchise on the cheap some housing in London.
mm.
It's based on Grayson and P&O,
Oh yes, yes, yeah,
which basically said that only one person can be in occupation at any one time, and usually that's the subtenant if you've sublet.
yes, yes.
I don't know why the judge took 152 pages to say that, but yeah,
Yeah,
there
yeah.
were a lot of the things besides.
Good, thank you. Okay. Um, so here's one for me. I didn't previously know that covenants in leases could be modified by the upper tribunal. I'm surprised that tenants don't do this more often. It seems like a relatively easy way of rewriting leases without having to use one of the insolvency procedures like a CVA. Yeah, so this is to do with Section 84 of the Law of Property Act 1925, and I guess that's a fairly familiar sort of provision in relation to modifying restrictive covenants in the freehold context, with by application to the Lands Chamber of the Upper Tribunal, and but it's maybe not such a high profile thing that it is also possible to modify covenants in leases under subsection 12 of 84 section 84. And I think part of the reason why it's not so familiar is because it's only long leases, and we live in a world of short leases. But it's got to be a lease granted for 40 years at least, and at least 25 years must have expired. So you don't see it that often, but I mean, there's been, I think, 3 or 4 reported cases over the past 5 or 6 years in relation to tenants doing this. I mean, I know of colleagues running cases of this sort as well. So it is something that has a use when it's available. Actually, there was a case, Black Horse Investments and Southwark London Borough Council, which was 3 or 4 months ago, I think, which was to do with a pub called the Black Horse in Southwark. And it was a really peculiar one, but it was quite a good illustration of the restricted scope of what you can do, because the pub tenant had made their application to the upper tribunal. There was a mix-up over the addressing of the notice of the application. It wasn't received by the landlord, which was Southwark London Borough Council, but it was held to have been validly served nevertheless. So the application went through on paper with no objection by the landlord, and the tenant simply got all the modifications it wanted to the various covenants in the lease. And it was about 3 years later, I think, that Southwark London Borough Council found out what had happened, by which time, of course, all the work had been done and new subleases granted and all the rest of it. At which point they applied to the tribunal to set aside the order. And it was a very peculiar sort of outcome, because they were successful in part because the jurisdiction is, first of all, to modify or discharge only restrictive covenants, and the application had been made to modify or discharge certain positive covenants, like keep open covenants in the lease, so that had to be set aside. And then there'd also been applications to or some modifications granted of covenants concerning, for example, alienation. And when it comes to leasehold covenants under subsection 12, you can only modify covenants relating to alterations and user. So the order which the tribunal made had gone beyond the scope of the jurisdiction of the tribunal. And quite where the parties are left, having some of these covenants modified and some of them not modified, and the alteration work been done and new subleases granted. I mean, the tenant is clearly in breach of covenant and rather on the back foot in negotiating things with the borough. But that's the way it went. But I mean, that's a kind of illustration of why I think tenants don't use this jurisdiction more often. Number one, because it's only long leases. Number two, because it's quite a restricted scope. I mean, you look at what tenants do with insolvency procedures. That they rewrite leases in a much more dramatic sort of way in relation to things like the amount of rent and shifting to a turnover rent and inserting break options and so forth. All stuff you couldn't do via via Section 84. And it's quite interesting. I think that the CVA procedure, when it was introduced back in 1986, the expectation was it'd just be a sort of relatively quick and informal way for small companies to put in place restructurings, which might deal with equity and debt and management structures and all the rest of it. And what's happened is we have this situation where large multiple retailers put in place these enormous CVAs which only deal with their lease liabilities. So it's a very odd situation we've ended up in. But I think there's much more scope to alter leases using the insolvency process, assuming, of course, the tenant to be insolvent. But that's my answer. Anything to add to that?
Yeah, the Section 84 12, I think it's not used as much. Like you say, it's only long leases. But there are a lot of long leases out there. Do you remember that? I'm sure you do. The IBM building, Basingstoke.
Yes. Yeah.
Basingstoke and Dean Borough Council, where Basingstoke objected to covenants against residential use and the likes. And this IBM building was vacated. It was on a very long lease. And Chevron Normandy purchased it, intending to convert into residential. And for whatever reason, the council objected to this. The landlord objected to this, but they were successful. The council objected on the grounds that, amongst other things, it would be the thin end of a wedge. If people convert their offices into residential. If one person does it, everybody else will follow suit, and we'll have no offices. If you go to Basingstoke, there's one thing they're not short of is. Yeah, so it's a strange argument. I came across quite a few issues in it a few years ago, because in England, back in 2015, it's changed subsequently. They introduced that was it class, I forget which one, class Q, where I think it's the one that you can convert offices into residential units. And a few years ago, you were getting a sort of masses of offices, redundant offices being converted into flats. And I'd seen it being sort of threatened as a way of, if you don't sort of relax the covenants, leasehold covenants and likes, this is what we'll do.
Yeah.
But I think there's a lot of ignorance to it.
Yes, no, that's right. But I say it's there as a tool. It can be used for that kind of thing. Okay. So next question: can all leases of churches be business tenancies? There's a novel one to me.
That's something I did mention. It's a case that was in my course. I think I mentioned it. It's certainly in the notes. Because well, again, you have to occupy under a lease at least partly for business purposes, but business purposes are not necessarily what people might imagine. Section 23(3), it's going to be a business is a trade, profession, employment, or any activity carried on by a body of persons, whether corporate or unincorporated. Years back, there was a 1970, early 70s, there was a case called Abernethy and A.M. Kleiman, where an individual was running a Sunday school from this premises. And they decided that wasn't a business premises because it's not a trade, profession, or employment. But if it's an activity carried out by a body of persons, whether corporate or unincorporated, all it has to be is an activity. Back in 2020, do you remember that Ruby Triangle, Jesus Ministry Sanctuaries?
No.
It was Ruby Triangle's off the old Kent Road, and it was earmarked for major development, something like 1,300 houses, but just one small premises within it. The development's going ahead now, but one small premises in it had been let out. There was some debate as to whether it was a lease or a license, but it was held to be a lease, as these things usually are, to this Jesus Ministry Sanctuary. And to cut a long story short, they fell in arrears with their rent. The landlords, Ruby Triangle, basically took objection to this and just entered and changed the locks. Usually you do that on a Sunday, but not a good idea for churches. Jesus Ministry Sanctuaries get an injunction to go back into possession and then sued. We had 54 Act protection, and the court decided you're a body of persons and it's an activity. I think the message is, you certainly don't have to be profit making, but a church can be if it's a corporate body as opposed to an individual running their Sunday school. And lots of things can be. And I think the message is, if in doubt, I would assume if I was the landlord, assume it's within the 54 Act and serve the warning notices.
Yeah. I've never come across that as an issue before. I know that there's, purely benevolent charitable community uses are outside the 54 Act, but it's not always easy to identify that. If you've got a drop-in centre for the elderly, you think that would qualify. What about if they have regular bake sales and so forth, and sell crocheted?
It's like all these. It's like all these things calling themselves licenses, which the vast majority are leases. A few exceptions like service occupiers, caretakers, and like. I think if you got any doubt, you contract. That's my new catchphrase, Mark. If in doubt, contract out. But I've been working on that for some years. You serve the warning notices, and I can't see anything wrong with serving the warning notices, without prejudice as to whether the Act applies or not.
No, quite. I was just wondering slightly facetiously as we were talking whether the Holy Trinity is a body of persons, an unincorporated body of persons.
We won't even go there.
Can an incorporeal body of persons be in business occupation? These are deep waters.
No, you're in my head.
Okay, we've got time for one, maybe two more questions. So this is one for me. Could you clarify what was the significance of the relevant wording in the Dunwood Properties and Isaac case being the form of a proviso? Funny little case, this one. Mr. Isaac bought his flat in Balham, and there was an estate agent on the premises underneath, and their lease ran out after a couple of years, and the landlord promptly converted the property into a bar restaurant and let it to a bar restaurant operator. So Mr. Isaac wasn't happy, and his lodger moved out, and he eventually sold the flat for about 3 years later for a loss of about £105,000. And he had claims against the landlord for breach of quiet enjoyment, derogation from grant, and nuisance, all of which the court dismissed in short order, saying that's completely hopeless. Just a question of the degree of disturbance, I think. But he was able to rely upon some wording in the lease instead, which is a bit unusual. And it was the wording was actually some rights reserved in the landlord's favour to carry out work to the property, but subject to a proviso that in doing so they shouldn't cause any diminution in value to the flat. If you think of, just sort of stepping away from that context, you think of an application for landlord's consent to carry out alterations, and probably the lease says, landlord's consent, provided landlord's consent is not to be unreasonably withheld. And of course, you're common law here, because the Landlord and Tenant Act 1988 doesn't apply to alterations, and the common law position is if you've just got a proviso like that, it doesn't give rise to any right to sue the landlord if they do act unreasonably. You can't claim damages from them, because the proviso is not a positive obligation on the part of the landlord. It's just wording which qualifies the earlier wording of the covenant. And that would have been a very sort of conventional approach to have taken to this wording, but the judge in this case took the view that it was very natural to see that wording as a positive covenant on the landlord's part, not to carry out work in such a way that it would result in a diminution in value of the flat. And I think Mr. Isaac was a bit lucky on that one, but that's the way that the court looked at it, and yes, that's the significance of the point. And I suspect, with increased repurposing of properties and increased kind of incidents of residential occupiers rubbing shoulder with commercial occupiers, that kind of dispute is something we might see more of, and it's almost always going to involve some tricky little points of interpretation of the lease, as it did in that case. So, okay, I think we've probably got time for one more. The last one for you, Richard. It could be a one-word answer, this one. If a landlord serves a break notice on the tenant, won't it just accelerate a continuation tenancy?
If it's a 54 Act, I think it's in the context I was talking about redevelopment breaks, and including redevelopment breaks, that B&M case, HSBC, from last year, but which is well established. There's a long line of cases from the 1950s that basically said that if the landlord's not ready for the development now, but might be, in the near future or whatever, then you can have a redevelopment break. Well, and if you serve the break notice, all it'll do is accelerate the continuation tenancy. But there was a case in the 60s, Scholl Manufacturing and Clifton Slimline, that said that your Section 25 notice can also be your break notice. You serve a 6-month notice and impose a new lease on ground F, and that's your break notice as well. You don't actually have to serve 2 notices.
Yeah. What was
not a bad idea.
I've forgotten the name of the case now. I'll forget my own name next. There's a case back in the 90s, wasn't it, where in the context of a falling rental market, there was the idea that a tenant could exercise a break option and then make an application for a new tenancy and get a new lease at a lower rent and bring their
Garston case.
That's the one, Garston and Scottish Widows, yeah. And that doesn't work for the tenant, because the tenant's break option is indeed treated in the same way as a break notice, or treated the same way as a notice to quit under periodic tenancy. It's an effective way of terminating the lease. But the same does not apply to the landlord's break. The landlord's break is not an effective method of terminating the tenancy, and therefore you just get the continuation tenancy. And so the landlord has to
has
to go through the hoops on ground F.
That Garston was back in the which a lot of people listening in will not remember, the the way the market crashed at the beginning of the 90s. And then
Mm.
people were using that kind of principle left, right, and centre until Garston and Scottish Widows came along and said you can't do that, basically.
Yeah.
You use
Yeah.
it as a downward rent review to all intent.
Yeah. There's also, just remember that the part of the issue in the Metropolitan Police Commissioner and Palace case in 2000, that one of the arguments there is if you've got a lease with a landlord's break option in it, it is not a lease for a term of years certain, and therefore you can't validly contract it out. Which, if true, means that the landlord's break option couldn't ever work. And luckily the Court of Appeal decided that was wrong, and even with a landlord's break option, it's still a tenancy for a term of years certain.
Yeah, it doesn't fit
Yeah.
nicely with the I've got the name of it now. The Rathbone Market case. I know it was from late 2008 or late 2007, and it involved Rathbone Market. It's in a famous case, and I can't remember the name. The one where we better finish now, but the one where they decided that it was purportedly excluded from the 54 Act, but that the lease said that the term included any holding over period.
Oh yes, absolutely, that one.
We can't finish until I remember the name of it. Famous case.
Refer to it all the time. It was
Old age.
Oh well, not to worry. That's the case that everyone thinks must be overruled at some point by somebody, but that was a Court of Appeal case, wasn't it? So anyway, there you go. So that I think is probably all we have time for. In fact, more than we have time for. So as I mentioned at the beginning, a recording of today's live Q&A will be sent out by email within the next few days. There's still time to watch the pre-recorded content. Your expiry date will be displayed next to the webinar. And there's still time to buy the complete event, including a recording of this live session, if you haven't already. So to book, just go to www.thesolicitorsgroup.co.uk, where you'll also find the online exhibition. And the exhibition is open for anyone to visit. If you've booked the entire event, you can claim your free 1-hour CPD webinar from the webinar learning catalogue, and that's worth £35 plus VAT. And finally, feedback forms for the event will be sent out when the event closes, and by completing that, you'll receive your CPD certificate. So that's all. Thank you once again.
One last thing. Thomas Van Staden and Newham Borough Council.
Thomas Van Staden and Newham Borough Council, of course it was. Well done.
Okay.
I would have been disappointed if you hadn't managed that right at the death, Richard. So thank you for that. And thanks everybody, and have a great day.
Thanks.